Hello, everyone. Welcome to Get Closed, Get Paid. This is a special edition with just Erin and I to review the MLS NAR changes expected in August of 2024 that are arising out of the NAR settlement. Big changes are up ahead, and we are hoping to go over all of those changes so you are prepared for new times ahead starting just next month, depending on when you're watching this. This is being recorded on July 19th, 2024.
Perfect. All right. So we're going to do our quick little disclaimer, which is, I joke, my favorite slide. That is actually my favorite slide. Kristen and I are attorneys, but this presentation is for educational purposes only. It does not create an attorney-client relationship. Also, we do serve on a number of committees, both with the Florida Bar, Florida Realtors, local boards. The opinions that we expressed here today are not necessarily reflective of those of our committees in which we serve. And this is our antitrust reminder that we always give before we present. Since this is not a live course, we're just going to show the disclaimer. Of course, the class is a forum for the sharing of ideas. We're not going to present any information that would be anti-competitive in nature. And now let's dive into our agenda. So we're going to talk about, we're going to give a recap of the real estate agent compensation lawsuits. We're going to do a recap of the NAR settlement and the practice changes that will be effective August 17th, 2024. We'll talk about buyer broker agreements, the new forms that have been released by Florida Realtors. We will review other new commission forms that were also released by Florida Realtors. We'll talk about commission rebates and lender caps and maybe some issues that exist with financing transactions as we move forward. And then Chris and I will have some final thoughts and discussion about what we foresee happening in the coming months. So let's get started. Kristen, briefly, can you recap what the lawsuits are about? If folks have had their head in the sand for the past year or so and don't understand really why these lawsuits exist and who filed them, give us a quick overview.
Yes. So at this point, it's been about 9 months since the Sitzer Burnett case went to trial. And at this point, everyone seems to kind of know what's going on. But just to recap, why are we here? Why are we going over the NAR settlement? That's because a lot of lawsuits have been filed in the real estate industry. These lawsuits are class action lawsuits, meaning groups of aggrieved parties have come together to file actions against various players in the real estate world, including the National Association of Realtors, various state organizations, and various brokerages. The crux of all of these suits are arguing unfair competition and antitrust type of claims based on how compensation has been paid in the real estate industry, namely how cooperating commission was offered on the MLS and paid to buyers brokers. Groups of home sellers specifically have argued that they were not allowed to, or they were incapable of selling their home and listing it on the MLS without offering and paying a buyer's broker something, and that is unfair. There's also groups of home buyers who have said that they've been left in the dark as to how much their agent, someone working on their behalf, has been paid, and because of that, that has increased the cost of the home that they have purchased, and they didn't have the ability to negotiate that commission because it was never represented to them that it was part of the transaction. So the result of all this is lots of lawsuits were filed. The one that we have talked about the most is the Sitzer Burnett case, and that is the one that made it to an actual jury trial first. That jury trial lasted for about a week in October of last year, and a decision was rendered by the jury on October 31st, Halloween, 2023. That decision awarded damages to the home seller class that brought the claim in the amount of $1.78 billion, which was subject to treble damages, meaning that number could actually be closer to $6 billion. Before the lawsuit went to trial, after the trial, there's been lots of settlements coming out of that case. Notably, Remax settled for $55 million, Anywhere Real Estate settled for $83.5 million, and Keller Williams settled for $70 million. The one we're going to talk about today is the NAR settlement. The NAR, the National Association of Realtors, settled for $419 million. And part of that settlement, NAR also agreed to change its rules and change its practices in the industry. These changes are sweeping. They make how you do real estate as a broker, no matter what state you're in, very different than maybe what you're used to. And that's what we're going to go through today. A few things to note, because the court process can be super complicated, is that this specific case does not have a final opinion yet as of the recording of this class, which is in July of 2024. The NAR settlement has received preliminary approval, meaning NAR settlement and agreement to pay the $419 million and agree to practice changes has been preliminarily reviewed and approved. Because it has preliminary approval, the practice changes are set to go live on August 17th, 2024. But notably, some of these changes, this settlement has been challenged. So it's still up in the air, it's still pending final approval, but what we know for sure is that the practice changes are expected to go live next month. So we're operating as if all of these changes are going to go through. Final approval of the settlement is expected in November of 2024. So yes, the practice changes are going to affect before the final approval, and that is just how this has been structured, and this is how we have to operate. If anything should change in November, we will be back. There's other lawsuits. This is not a comprehensive list. This is a list of some of the lawsuits out there. Notably, Parker versus Florida Realtors is the case you want to look at, because that involves Florida-based realtors, which is what this class is geared towards. Parker is a little bit different than the other antitrust class action lawsuits in that it's based on Florida law, not federal law. However, the settlement process has provided some path towards resolution on that case, and that case is currently stayed pending final approval of the settlement agreement in November. So that case is still out there, it's still active, but it is slightly paused until possible resolution of these other types of claims.
All right, so let's talk about the NAR settlement proposal itself. Again, as Kristen mentioned, they agreed to $419 million plus practice changes, and we'll go through in detail what those practice changes are, who are covered under the settlement: MLS members where their brokerage residential transaction volume is less than $2 billion. And then larger brokerages have the opportunity to opt in to be included and covered under the settlement. And of course, inclusion in the settlement requires compliance with the practice changes. So what are those practice changes? Let's go through them. The first one is to eliminate and prohibit requirements that sellers offer compensation to buyer brokers or buyer representatives. So whereas previous rules required, various MLS boards required compensation of something to a buyer broker or buyer representative in order to list the property on MLS, that is no longer required. Number two, removing compensation from the MLS, so you cannot make offers of compensation, or cannot make offers of compensation on the MLS or disclose the compensation itself on the MLS. Also, number three, MLSs are required to eliminate broker compensation fields on the MLS and prohibit the sharing of offers of compensation to buyer brokers. Again, all within the MLS system. And it prohibits conditioning listing on MLS on offering compensation to buyer brokers. Again, those are all related to MLS and how the listings will appear. You will no longer see an MLS field. Buyers brokers will have to contact directly the listing agent to determine if there's any offer of compensation from the listing broker or from the seller. Kristen?
All right, so what else do we have? Number five, compensation may be advertised off of the MLS on the broker's own listings. So while you won't be able to make offers of compensation on the MLS, you still might have the opportunity to offer compensation if your seller is agreeable to that, but it's going to be through a different forum. And it's not going to be somewhere where compensation offers are combined and aggregated. Number six, this is probably the biggest, I think, change that a lot of agents are trying to overcome, and we're going to spend a lot of time on this today. All realtors are now required to enter into written agreements with their buyers before a buyer tours a home. This is typically a buyer-broker agreement. It could, in theory, be a different form of agreement, but there has to be some sort of written agreement between the buyer's broker and the buyer before you start providing services to the buyer. That agreement must specifically state that a disclosure of the amount of rate of compensation that's going to be paid to the broker. The amount of compensation must be objectionably ascertainable, which we're going to explain what that means in a little bit, and may not be open-ended based on what the seller is offering. What that means is you have to set your commission based on what you want to be paid and not what another agent or a seller in a transaction is offering. It has to be based between a negotiation between the buyer and their customer. I mean, sorry, a buyer and their broker.
And their broker.
Yeah, and the realtor may not receive compensation for services in amount that exceeds the rate as stated in the agreement. What that means is that if you negotiate a certain amount, we do not use numbers in this presentation, but if you negotiate a certain amount between yourself as a broker and your buyer, and then a commission that is more than that is offered through a listing broker or a seller, you cannot accept that larger amount unless your buyer agrees to it. So you can only accept what is actually in that initial agreement.
Thank you. So also our practice changes is neither buyer nor seller's realtor can represent their services as free. Again, their services are not free. Realtors typically do not work for free. They get paid a fee. So we want to be open and transparent about that. Also, they need to conspicuously disclose to sellers and also obtain sellers' written approval for any payment or offer of compensation to a buyer's broker. Also, conspicuously disclose to all customers that, quote, broker commissions are not set by law and are fully negotiable. This big, bold language, I call it, you'll see in all compensation agreements and many other forms throughout Florida and in your respective states. So you'll see this big, bold language everywhere. It's important for our customers to know that broker commissions are not set by law and are fully negotiable. Also, number 10, it'll disallow MLS subscribers from filtering listings based on compensation, which, of course, if there are no MLS fields for MLS compensation, compensation fields for buyer broker compensation in MLS, of course, you can't filter your listings by it. So again, we're not allowed to filter our listings or not show listings based on compensation. The idea is we want to make sure that our customer has the opportunity to view all properties, and if they would like to self-select to not view certain properties based on the compensation that may be offered to a buyer's broker, the buyer can certainly self-select. I've got a link to a website here for NAR. Some of their FAQs have recently been updated, so I encourage you to check those out as they're updated. All right, what do the practice changes not do?
Okay, so the practice changes do not prevent offers to buyer brokers outside of the MLS. We kind of mentioned that before. So if you're a listing agent and your seller wants to offer compensation, they can do so, but it's not going to be on the MLS. It's got to be an offer made on your own advertising, on your own website, something of that sort. The changes also do not prevent sellers from offering buyer concessions on the MLS as long as the concession is not conditioned or tied to the payment to a broker. Advertising of concessions, however, is subject to various MLS rule changes. Some MLS services are going to allow the concession field or add a concession field. Some will have the option to advertise concessions and some will not. So while you might have the ability to advertise the concession on the MLS, it's going to be subject to MLS rule changes. So keep an eye out for those. Those are coming out as we speak. So wherever you are practicing, make sure you check with your local board. The practice changes also do not specifically address commission on rentals. That is also something to monitor when you look at the MLS rule changes. Many MLSs have indicated that they're going to remove the commission field just completely from the MLS, in which case you're not going to be able to offer on rentals either.
Yep, so if you practice in multiple locations and you're a member of multiple boards, make sure you're following the guidelines for each of those boards for your listings where you're advertising them. All right, so we're going to talk a little bit about the DOJ. So in 2020, NAR and DOJ reached a settlement agreement regarding certain of the NAR policies, including cooperative compensation rule and clear cooperation rule. After that settlement, however, DOJ reopens its investigation, NAR challenged, DOJ appealed, NAR petitioned for rehearing in May of 2024, and that court recently denied that rehearing. What does that mean? It leaves the DOJ open to be able to reopen its investigation into NAR policies. So stay tuned on that. If you hear anything in the news that's really between NAR and DOJ, you're going to sort of understand there's a little bit of tension. Know that the DOJ is investigating policies by the National Association of Realtors. Also, the No Select case Ms. the MLS PIN case, DOJ did file a statement of interest. That case has been stayed until after the Sitzer approval or the culmination of the Sitzer case in November of 2024, so something to pay attention to. That is how we know sort of where the DOJ, their opinion on broker compensation. And we'll talk about that in just a second, but also the DOJ did file a formal inquiry into the California Association of Realtors as they were about to release their new forms, their sort of entire forms library that is generally updated every couple of years, similar to Florida Realtors and some of your local boards that issue their own contracts. The California Association of Realtors delayed some of their settlement-related forms, the release of those forms during the pendency of that investigation or the inquiry. So what does DOJ want with respect to broker compensation? We know what they're looking for, what they're hoping for, based on their statements of interest and some of their comments from some of these cases, is they would like what I'm calling decoupling. So prohibiting of offers of compensation to a buyer's broker by a listing broker or seller. So and what I'm saying is if DOJ had their way, buyers would be the only people paying the buyer's agents, and sellers would be the only people paying the seller's agents, and they want to keep that sort of that process bifurcated. That is not the case now. We do have the opportunity for a seller or a listing broker to pay buyer broker compensation or to provide a credit to a buyer towards buyer broker compensation. But the idea is we want to make sure that it is completely transparent, that process is transparent, and also that that buyer broker is receiving compensation in an amount that's no higher than that agreed upon amount in that buyer broker agreement. So how can our real estate friends navigate this shift? Realtors really need to do a great job of explaining what they do and how they're compensated. So again, we're going to increase transparency, not just in compensation, but also in what buyer's agents do and how they can help their clients throughout the transaction. They need to articulate their value. And what I encourage folks to do is, I know sometimes we want to hide our clients from some of the mess that we either avoid or help work our clients through. Explain to your clients all the problems and hurdles you're able to help them overcome that they may not be familiar with. They may not know what could come up in a transaction. And so unless we're able to articulate our value and say, for these services and for these problem avoidance strategies that we have, this is my value and this is what I should be compensated for. And then of course be able to articulate that in a buyer agent presentation. Also, it's very imperative that all parties agree to those commission terms in advance and document to avoid disputes at closing. And we'll talk about that a little bit when we talk about enforcement of these agreements. But just know that, again, because buyer brokers are not going to know by looking at MLS what offer of compensation exists, it's important that the buyer broker get in touch with the listing agent and find out if there is an offer of compensation either between the listing broker or the seller to offset some of those fees that buyer would be obligated to pay under the buyer broker agreement. Have that conversation early and often, and then document those agreements, whether the agreement is between the between the listing broker and buyer broker, or whether the agreement is between the seller and the buyer broker. Make sure that you're able to document those agreements. All right, here are some examples of how this might play out, and then we'll talk about some of the forms that have been released to kind of help guide us through this scenario. So we have a buyer who's entered into a buyer broker agreement with the buyer's agent agreeing to pay X dollars for their services. Again, this is at the time, the initial meeting where the buyer said, yes, I would like to work with you agents to assist me and provide buyer representation services, buyer services through closing, whether that's touring the property, negotiating an offer, anything on behalf of a buyer. Buyer will be entering into a buyer broker agreement with the buyer's agent. And of course, that agreement will set forth the fee that they're agreeing to pay their agent. Now, let's say the buyer has identified a property that they'd like to see. The buyer's agent is going to contact the listing agent to determine if the seller or the listing broker are offering compensation to the buyer's agent prior to submitting the offer. So in one scenario, option one, perhaps there is no commission being offered to the buyer's agent from the listing agent or from the seller. In that instance, then the buyer would be responsible for paying X to the buyer's agent at closing, because that is the amount that is agreed upon in that buyer-broker agreement at the beginning of the buyer and buyer's agent relationship. Option 2, perhaps there is some commission that's being offered to the buyer's agent directly from the seller or through the listing broker, and it's negotiated in a separate agreement. So you contact, as the buyer's agent, you contact the listing agent and ask if there is any offer of compensation, and then you're going to document that agreement accordingly. So there's a form for a listing broker directly to a buyer broker, or between the seller and the buyer broker, and you want to document those agreements. Option 3, perhaps the seller is offering a concession directly to the buyer at closing. So this would be negotiated and documented in the sales contract. So credit between seller and buyer, either towards closing costs or towards the buyer's obligations to the buyer's agent. So option 1, again, let's say the listing and selling broker is saying, nope, I'm not offering any compensation. Then that buyer would be responsible for paying whatever fee they agreed to for those buyer agent services in the buyer broker agreement. Option 2 is you're able to get either some or all of that buyer broker compensation paid for, offset or paid for by the seller or the listing broker. And those will be negotiated in a separate agreement between the buyer's broker and the listing agent, or the buyer's broker and the seller directly, or failing 1 or 2, but let's say the seller may be willing to offer a concession to the buyer directly, depending on the other terms of the contract, the purchase price, the other closing terms. Then perhaps in the sales contract or an addendum to sales contract, you'd have a negotiation of a seller concession towards buyer closing costs or towards buyer's obligation to the buyer's agent for buyer agent compensation. All right, we're going to talk about the forms that we just referenced. So we're going to talk about generally the elements of buyer broker agreements, and then we're going to dive into the specifics. So just know that Florida Realtors has released their forms. There are also forms that have been prepared by local brokerages and local firms for use. So you want to make sure that you're using the form that is approved by your broker. You understand its terms before you present it to your consumer. But generally, they all address these same overarching themes. We're going to dive right into the exclusive buyer brokerage agreement. If you look at the exclusive buyer brokerage agreement, the top of the form is going to look the same for all 4 versions of the form. There are 4 versions of the exclusive buyer brokerage agreement. You're going to look at the bottom left corner to find out which version of the form you're working with. And the difference between these 4 forms has the letters after the number 7, has the letters, like for example, this one is TB for transaction brokerage. So the difference between these 4 forms really is the type of brokerage relationship that the broker will have with the consumer or buyer. So we're looking at, again, exclusive buyer brokerage agreement. Top left corner, they all look the same. Bottom left corner, we're looking at the footer that will tell us what version of the form we're working with. And again, the letters TB equals transaction broker. That's the type of relationship that most folks have here in Florida, but know that there are other versions of the form that deal with single agent, no brokerage relationship, or the consent to transition from single agent to transaction broker relationship. So we're diving right in. To note one thing about the form, if you've been using the Florida Realtors form before, it used to say buyer as the party. Now it's changed to consumer to really more comply with the fact that this form can be used with not just purchase contracts, but also leases as well. So we're saying the agreement is between the consumer, in this instance, think of it as a buyer, and the broker. And again, the broker is the name of the brokerage company, right? So we've got a buyer and the brokerage. This agreement is an exclusive agreement for the right to work with and assist the consumer in locating and negotiating the acquisition of suitable real property as they describe below. And here we're saying acquire, acquisition includes the purchase, option, exchange, lease, or other acquisition of ownership or equity interest in the real property. So we've got the who, we've got the what they're authorized to do, and we've got the term of the agreement. Note that this agreement will begin on X date and terminate at 11:59 p.m. on the end date. Note, there is no default time period here, so you're going to want to make sure that you have a commencement date and also a termination date. Kristen, if folks forget to put a termination date here, what would you argue that the term of their agreement is?
I would argue that it's only 1 day.
Uh,
What's very tricky about this agreement, and is that there's no default provisions. You might be used to default provisions in the purchase contract, which are those catch-all type of provisions that help to prevent a situation where you don't have an enforceable agreement because you didn't fill out a blank spot, which happens. We're all human. But the crux of the antitrust lawsuits is that there hasn't been transparency and there hasn't been ability for consumers to negotiate properly with real estate professionals. All of these contracts are now really set up in a way that all the terms are negotiable between broker and the consumer, including the term. So how long this buyer agrees to work with you, or this consumer, and it could be a tenant, agrees to work with you, is something that you have to discuss, and you have to mutually agree to, and you have to write it into the blank. If you left that blank, I would argue you only had a contract for the one day. All facts are different, so I'd have to see the specific circumstances. There's different legal arguments that can be made to say maybe it went on for longer, but best bet is to make sure you fill that contract out properly with a term that's going to allow you to be protected as a real estate agent that might be working with a buyer for some time to find a place.
Yes, yes. So the first few times you're going through these forms, make sure you pay attention to all of the blanks and make sure you're completing the blanks that exist in the form. Note that there are no little asterisks to the far left column of the forms themselves. So you're going to really have to pay attention to where the blanks are and make sure you're putting, inserting those terms. So while we've got, let's say we have a 30-day agreement, for example. If the consumer enters into an agreement to acquire property and that's pending on this termination date of the buyer broker agreement, then the agreement, of course, is going to continue into effect until that transaction has closed or is otherwise terminated. So you enter into, if the buyer enters into a sales contract prior to the termination date of this agreement, of course, the terms of this agreement and the enforcement mechanisms of this agreement will continue until that transaction has closed or until the transaction otherwise terminates. Property. So if you're used to the old form, it had a few more blanks when we're dealing with property. This is where we want to caution you to be very mindful of the terms you include in both the type of property and the location. So we're saying our consumer is interested in inquiring about property acceptable to our consumer, such as type of property. What kind of property is it your buyer is looking for, and where? And while we say be mindful, we know that our buyers don't always know exactly what they're looking for. They might say that they're interested in a single family home in Naples. What they really might want is a townhome in Stewart, right? And so if you put in your buyer broker agreement the type of property, single family home, and the location, Naples, and your consumer ultimately buys in Martin County, your brokerage agreement's not covered here. Now, you may have an argument that you should be entitled to compensation otherwise, but make sure if you're willing to work with the consumer throughout the state of Florida, that your location is the state of Florida. If you only work with a particular consumer in one county, then just know that when you limit that location, you may be limiting your opportunities to be stated. So, Kristen, if you were to put the broadest terms possible, excuse me, under paragraph 3, what would you say for type of property here?
I would put all residential and commercial units, or all commercial and residential types of properties. You could also put vacant land if you are potentially looking for, or your buyer is looking for vacant land. So you could also put any, or something to that effect. For location, I would go as broad as you are willing to go for that buyer. And in the world where you can represent clients by Zoom and things like that, by maybe partnering with other agents in certain areas, you might just want to put Florida. There could be a situation where there's a transaction that you maybe don't want to handle. But you could always refer that out, or you could co-broke it and still work the transaction for the consumer without maybe physically opening the doors and things like that. So it's whatever you have the ability and whatever you're comfortable with providing services to, what area you're comfortable providing services in, I should say. If you do not do transactions outside of even one specific neighborhood, then maybe the location is appropriate for that situation, just to put the neighborhood. But I encourage everyone on both subpart A and subpart B to go as broad as possible, because you just don't know where the buyer is going to end up. And a lot of times
Yeah,
I don't think the buyer knows where they're going to end up, and that's fine.
yeah, that's true. That's true. And one other thing, before you present this to your consumer to execute, have a conversation with them and ask them very specific questions. Have you entered into a buyer brokerage agreement? Have you entered into an exclusive buyer brokerage agreement? Because you don't want to have your consumer enter into two agreements to cover the entire state of Florida, and potentially the buyer could be on the hook for paying 2 agents at closing, or 3 agents, or 4, right? So we're going to ask very good questions, just as you would ask a seller, have you entered into a listing agreement with a real estate agent for listing your property? You're going to ask those questions of your consumer. Okay. Paragraph 4, these are the broker's obligations. And there's nothing in here that a broker is being required to do that they don't already do, right? Brokers are going to use their professional knowledge and skills. They're going to discuss the property requirements. They're going to assist the consumer in viewing those properties and touring those properties. They're going to assist the consumer in negotiating the sales contracts. You guys do that all the time. You're also going to cooperate with the other real estate licensees that are working with the owner, if there are any, to complete the transaction. So this is, again, these are the services you as a broker, a buyer broker, are saying I will be obligated to do. Just that. Also, we're having our consumer understand that you as a broker could also work with other potential buyers who might want to acquire the same property as the buyer. If the broker submits any offers by other competing consumers, the broker will notify the consumer that there's a competing offer, but cannot disclose the other offer material terms or conditions. And the consumer, of course, agrees. The broker may make competing consumers aware of the existence of your offer, but not reveal any of those material terms or conditions of the offer without that buyer's written consent. And the consumer understands that even if the broker is compensated by an owner, seller, or another real estate licensee, like the listing agent who is working with the owner, so the compensation, wherever it comes from, doesn't compromise that broker's duties to the buyer, to the consumer. Also, the broker is going to adhere to the Fair Housing Act and is not going to participate in any unlawful discrimination. And my favorite, paragraph 4D, the broker is not warranting or guaranteeing the products or services provided by a third party, but it's going to encourage that agent to refer to the appropriate licensed parties, to the appropriate vendors, to your tax professionals, to your legal professionals, and the broker can be a really great source of referrals for that consumer. All right, what are the consumer's obligations here? So the consumer is agreeing to work exclusively with the broker to accomplish their objectives of this agreement, including conduct all of their negotiations only through the broker, and refer to that broker all inquiries of any kind whatsoever. Also, they're saying if the buyer's contacted by an owner or real estate licensee who's working with an owner or views a property unaccompanied by their broker, the consumer will advise the owner or the real estate licensee that they are working with you. They are working with that buyer broker. Also, they're going to provide the broker and other third parties with accurate information requested by the broker in connection with their ability to acquire the property. They're going to agree to be available to meet with the broker at reasonable times to view properties. They're going to hold the broker harmless from any losses, damages, costs, or expenses of any kind, including attorney fees, and from liability to any person that broker incurs because of acting on the consumer's behalf. The consumer is saying that they will not ask or expect the broker to restrict the acquisition of property that would violate fair housing laws. And the buyer is saying they will consult the appropriate professionals for legal, tax, or engineering advice and that kind of thing. And also, paragraph 5G, the buyer is going to make a diligent, good faith effort to perform their contract terms of any purchase agreement or contract to lease and close on the sale of any property that the consumer contracts to acquire. Again, this is the buyer making a good faith effort to perform the terms under their sales contract that they enter into with a seller. All right. Let's talk about some money. Kristen, you want to talk about retainers?
Yes. So the retainer concept has been in the buyer broker agreement for Florida realtors for quite some time. I don't know a ton of agents that do it, but Erin and I have taught this class many, many times, and we always ask because we're always curious. And we have heard of some folks who do take a retainer. what we've heard is that a retainer might be taken in a certain amount, and will be good for a certain amount of showings, for example, or a certain amount of written offers. Some sort of catch-all amount to just cover upfront expenses for a certain amount of services that are rendered between a buyer's agent and the consumer. We've also seen it as a nominal amount, such as like a transaction fee or something like that, that just puts some sort of money into the transaction, to make sure the buyer is serious. Do know that retainers are considered commission income under Chapter 475. So if you are going to collect a retainer, it needs to be paid through your broker, however that works. But you cannot collect as a real estate sales associate. You can't collect commission income directly to yourself. So just know that that is considered compensation. As to the compensation paragraph, we can dive into that. This is the important part that everyone needs to pay attention to and fill the blanks in, like we discussed before, or else you will be paid zero. Erin, do you want to dive into the first part and then I'll get into the numbers?
I do. Yep. And one real quick thing about retainers. So we have had in some of our other presentations, we've had some agents who say, well, how is my retainer split between me and my broker? You know, how is this divided? The answer will lie in your independent contractor agreement. So make sure you are reviewing that. If it is silent as to retainers, have a conversation with your broker that if your practice is going to include the requesting of non-refundable retainers, again, that would be in addition to any compensation that is set forth in paragraph 7, that your independent contractor agreement addresses how that will be split between broker and agent. All right, paragraph 7, we're saying the broker's compensation is earned under this buyer broker agreement when a consumer or any person acting on behalf of the consumer contracts to acquire real property as specified in this listing agreement or default under any contract to acquire property. So the compensation, of course, is for the broker services to our consumer, and the compensation received by the broker, if any, from any owner or owner's brokers for services rendered to the consumer will reduce any amount owed by the consumer under this paragraph. What does that last sentence mean? That means that we have this agreement that between a buyer and buyer's broker, and if the buyer's broker is able to negotiate that the listing broker or the seller pay the buyer broker directly, then that's going to offset the amount of money that's due under this agreement. So if the listing broker or seller are only willing to pay a portion of what the buyer broker is due under this buyer broker agreement, then it will reduce the amount that is owed under this agreement. But perhaps the listing broker or the seller may be willing to pay the entire amount that is due under this buyer broker agreement, again, subject to negotiation between the parties. But again, it wouldn't be the instance where a buyer broker would be compensated multiple times, right? So the buyer broker is only able to be compensated the amount that is listed here in the buyer broker agreement. And if the buyer broker is paid directly either from the owner or the seller or the owner's broker, listing agent, then that would offset whatever was due from the buyer at closing. All right, let's talk about the terms, Kristen.
I just want to add one part. So new language that's in this new form of contract is that the compensation is for broker services to the consumer. There's some additional language that's actually falls at the end of the contract, but ties back to this paragraph that explains that this amount that is set in the buyer broker agreement is only for the buyer side, tenant side of the transaction, and does not impact the total in the event you're representing both the buyer and the seller. So just know that the compensation you set here is the compensation you're setting for providing services to the buyer, not potentially if you're acting as a transaction broker in the state of Florida, you might have both sides, and that is addressed. It's just not addressed in this paragraph, even though for the purposes of our presentation, I'd rather it be addressed now because that would make this flow better. But just remember when we get to that part, it ties back to this paragraph. So you've got 3 options here. Section A is for purchase or exchange. Section B is for lease, and Section C is for option. And then you have the Erin's least favorite, which is additional fees and a big blank line, which always makes her nervous because what are you going to add to that big blank line? On line A, for purchase and exchange, you have two options to fill out. And we've gotten some folks who have said this is very confusing. So we just want to walk you through it. You've got two options. You can either fill out a flat fee amount or a percentage as what the commission is, or you have the option of filling out a flat fee, a percentage, plus another flat fee. So in my opinion, the first section would be if you just charge a commission, whether flat fee or percentage, and that's it. The second, you would use the second part of that sentence if you charge a commission in some form, whether it's flat fee or percentage, plus another fee, such as a transaction fee, a document saving fee, one of those types of fees that your broker maybe charges that's in addition to the commission. If you've got two types of fees, then you're going to do it in the second section. This compensation is due no later than closing. But closing is not a prerequisite to sale. So the big misconception I hear a lot, especially with new agents, is my commission is due at closing. It might be due at closing, but it's actually earned upon the purchase contract being executed, and potentially it could be earned upon the purchase contract being defaulted on by the buyer. Those are very fact-specific scenarios, so don't go assuming that you're entitled to commission in certain circumstances, but just know that it may be due even if a closing does not occur. Do you want to dive into pieces?
No. So similarly, you're going to select how you're compensated. Again, there are no default provisions here. So it's either a fee or a percentage of the monthly rent, or a fee or a percentage of the monthly rent, plus, again, something like a transaction fee or some sort of additional fee. So again, make sure that you're filling in the blanks where appropriate. You're selecting either or. The first half, again, is there a dollar amount or a percentage of the month's rent, or if you charge a flat fee or a percentage of the monthly rent plus a dollar amount, again, for transaction fee, then you're going to use that second set of lines. For an option, the broker is going to be paid that subsection C, a dollar amount or a percentage of the option amount to be paid when the consumer enters into the option agreement. If you're dealing with options or option to purchase or lease options, make sure you're working with counsel to help go through those forms for your consumer. And well, so the moral of the story is, one, make sure you're paying attention to the blanks so you're completing them appropriately, but also there are no default provisions here. So make sure you're putting in the negotiating your appropriate fees here. I think that's it. Yeah. All right. Let's move on. All right. We've got a protection period. So we have our lease or our term of our buyer broker agreement. The consumer is going to compensate the broker if within blank days after our termination date, the consumer contracts to acquire any property that was called to that consumer's attention by the broker or any other person found by the consumer during the term of the agreement. So we've got, let's say a 30, for the sake of argument, let's say we've got a 45-day term of our original buyer broker agreement and it ends today. For example, we've got a 30-day period if we use the default provision after that termination date, that if the buyer purchases or contracts to acquire any property that was called to their attention during our original 45-day term, then the broker would be entitled to compensation. However, the consumer's obligation to pay that broker's fee, meaning the buyer's obligation to pay the fee for a property that was called to their attention during that 45-day period, ceases if the buyer enters into another good faith exclusive buyer brokerage agreement with another broker after that termination date. So if you're familiar with our listing agreements, they're similar, right? You've got a protection period for a period of time after the term. If that buyer enters into another exclusive buyer brokerage agreement, a good faith exclusive buyer brokerage agreement, then essentially it's cutting off that protection period. Kristen, do you have anything to add about the protection period?
No, you do have the blank there, so at least you have that.
Yeah.
But I would say I would still encourage you to fill that out because 30 days isn't a huge amount of time. And also just be aware of that sentence too, also as it relates potentially to when you're signing new buyer broker agreements. When Erin mentioned having conversations with your new buyers when you're commencing a relationship, you need to ask if these agreements are in place. And
Yeah.
it can be challenging to figure out if they're still in place. Is there anything subject to a protection period? Also, this is just one form. There's lots of new buyer broker agreements out there, and they may
Yeah.
differ in how the protection period is treated.
Correct.
Just be aware of all those intricacies and make sure you get those worked out in advance before you undertake to work
Yeah.
with a consumer who may end up in a situation where they're owing
Yeah.
multiple commissions to multiple brokers. And maybe not even
Yes, there are.
intentionally. Maybe they just unknowingly have signed more contracts than they realized, or signed on to terms they didn't realize.
Correct. There are some versions of buyer broker agreements, not the Florida Realtors forms, but I've seen that do not have that cutoff period. So there is sort of an extended protection period that is not cut off by a buyer entering into another exclusive buyer brokerage agreement with another firm. So again, that could potentially put your buyer in a position where they may owe double compensation. So again, make sure we ask the good questions up front, and then also make sure that we are proceeding at moving forward. Kristen, do you want to talk about conditional termination?
Yes. So the agreement.
This is different, very different.
Yes, the agreement can be terminated, but it's the language actually reads broker may agree to terminate this agreement. If broker agrees to terminate, customer will enter into a written agreement and pay a cancellation fee. What's important to note is that this is a broker's discretion. So this is a situation that allows a broker to potentially terminate a contract if things are not working out. But it gives a little bit of protection to the to the broker, in that the buyer is not going to be able to just terminate, say, if they want to work with another buyer because they've given them a different compensation structure and you've already negotiated out a transaction. You want to make sure that your efforts are protected. That's why it's conditional on the broker agreeing to the termination. You can insert an amount there. Again, there's no default provision. So my opinion is that if you left that blank, it would be considered zero. But remember, this is at broker discretion. So you can negotiate the terms of that exit from the agreement as you see fit, based on this language. Does that answer all the questions?
Yes. Again, make sure you fill in the blank if you're expecting a cancellation fee. But you're right, the broker does not have to allow the termination of this buyer broker agreement. They may want to, and again, there may be a situation where the relationship between the buyer and the buyer broker is just not working out, and of course they may want to go ahead and release that buyer from the termination. But know that even if you put a dollar amount here and they agree to a conditional termination, the broker may have the ability to void the conditional termination. And the consumer is going to pay the broker compensation less the cancellation fee if between the early termination date through that termination date plus the protection period, the consumer enters into a contract to acquire property, which prior to that date was found by the consumer. So there isn't a scenario where a buyer could say, I'd like to terminate, and then the following day enter into a contract for property that was brought to their attention by the buyer broker. Again, they can't. They can't avoid compensation by just saying, "Hey, I want to willy-nilly terminate. Let me out of the buyer broker agreement because I don't want to pay the buyer broker," and then enter into a contract, the day after to be able to avoid that buyer broker compensation. All right. Okay, Kristen. Who just as a matter of course, who can sue a buyer under a buyer broker agreement? Who has the authority to do that?
Only brokers. So commission lawsuits have to be brought by the brokerage because all compensation is due to the broker. So keep that in mind. If you are ever in a situation where you believe compensation is due, you have to work with your broker to figure out how those claims are made. If a claim is made, you're going to make it pursuant to this paragraph. If it's a claim directly between you as the broker, or sorry, not you, but the broker and the consumer. So this is set up that all controversies and questions between the parties will be settled by first attempting mediation. And then there's an option to move forward to litigation unless both parties agree to arbitration, which would be done by initialing those lines. There are certain situations where prevailing parties would be entitled to recover reasonable attorney's fees. That is in the situation where litigation action is filed. But the last part of the arbitration clause actually reads, each party to any arbitration or litigation will pay its own fees. So know that fees change depending on what option you select for your dispute resolution clause. But I encourage you to keep that in mind because that can greatly impact your ability to kind of recover some of these commissions. Conversely, these contracts can also be subject to potential litigation by a consumer against a broker for failing to provide services in connection with the agreement. So just keep that in mind that these are not necessarily only agreements to enforce commission. This could also be grounds for a consumer to file action against a broker for failing to provide services or being negligent in their representation or something of that effect. So keep that in mind and discuss with legal counsel and your broker kind of the ramifications of what option you pick for dispute resolution.
So that's a good question. So again, this buyer broker agreement is negotiated between the buyer and the broker. But before you select the arbitration clause, I think as a buyer, an authorized associate, you should have a conversation with your broker as to whether the broker is willing to go through arbitration or prefer to move forward through litigation instead. Paragraph 11 allows the broker to assign the agreement to another broker. This makes sense if you were a buyer broker and you switch brokerages. Again, this buyer broker agreement can be assigned from one broker to another. And as I mentioned, paragraph 12 is the paragraph that really is different between these four different buyer brokerage agreement forms from Florida Realtors. This paragraph 12 defines the type of brokerage relationship that exists in this agreement. Again, we're looking at this footer, the bottom left corner, EBBA-7TB for the transaction brokerage relationship, and that relationship is defined in paragraph 12. Again, broker will act as transaction broker, and it sets forth all of your obligations as a transaction broker. They're set forth in chapter 475. And the last provision, of course, that gives me heart palpitations is paragraph 13, where it has blank lines and an opportunity to include other terms. I strongly encourage you, if you're a buyer's agent, to discuss with your broker before including additional terms here, and also make sure that the terms are either approved by your broker and or broker's counsel to make sure that the terms are clear, understandable, enforceable between the parties. Again, I'm not saying don't use these lines. I'm saying proceed with caution, yellow flashing lights. Make sure that you have whatever terms that the parties are agreeing to, make sure it is approved by your broker and authorized by your broker, and of course, preferably reviewed by people. All right, paragraph 14 is our acknowledgement language, and let's just go through this because this is very important. It's about our big bold language as well. Saying the consumer, our buyer, has read the agreement, they understand the contents, they understand the agreement can't be modified except in written agreement signed by both parties, again, signed by the consumer and signed either by the broker or its authorized associate. We can sign this electronically, that's fine. This big bold language that is underlined here, again, this is part of the settlement. It says brokerage commissions are not set by law and are fully negotiable. And also part of the settlement, as we talked about before, the broker may not receive compensation from any source that exceeds the amount or rate agreed to with the consumer. Again, from any source, the broker cannot accept compensation from any other source that exceeds the amount in this buyer broker agreement. However, consumers agreeing that the broker may. So, however, the consumer agrees that the broker may receive separate compensation from the owner of the property for services rendered to the owner by the broker for which the consumer will not be responsible. So, as Kristen mentioned, this language, this sort of however language, really pertains to our compensation discussion in paragraph 7. So, this buyer broker agreement is solely with respect to services to the buyer. A broker could receive compensation for services to the seller. That would be under a listing agreement, some other brokered compensation agreement between the seller and the brokerage. Between the seller and the brokerage, of course, the buyer would have no responsibility here, and the buyer would only be responsible for the compensation that's listed in the agreement between the buyer and the broker. So all that to say is your brokerage could potentially be on both sides of a transaction, but the fees owed by the buyer and the fees owed by the seller would be under separate agreements. Is that fair to say? Okay.
Yeah.
who is signing this and what additional information do we have? It's great. We've got their consumer name, signature, of course, their mailing address, phone number, email, all of that stuff. And then we've got our signatures at the bottom. Kristen, let's talk about who can sign this darn agreement and what might this mean moving forward for some of our agents who, maybe need broker authorization or need brokers to sign everything, every time, all the time.
So this agreement can be signed by an authorized associate or broker. So who that person is going to be dependent on your broker's policies. Some brokers will require that the qualifying broker sign all agreements, or perhaps they delegate that authority to someone in their office. Other brokers may authorize all of their agents to sign their own agreements. It's going to be office dependent. So I encourage you to determine that in advance, because you don't want to get into an issue of whether there was parent authority or actual authority and all these certain legal issues that can come up with whether a document was executed properly. So have that conversation with your broker now as to who is authorized to sign broker agreements, who's authorized to sign buyer broker agreement amendment documents, and any other agreements that might be coming down, such as listing, etc. And then that will answer that question.
Awesome. Thank you. Thank you. So just a quick note, as I mentioned, paragraph 12 will differ depending on what form you're using. So I just wanted to show you guys what the EBBA-7TN, which is the transition from single agent to transaction broker language, looks like. Again, if you're looking at the form, top left, header, exclusive buyer brokerage agreement looks exactly the same, but bottom left corner, the footer is EBBA-7TN for a separate type of form. Paragraph 12, we'll talk about the brokerage relationship. Again, this is referencing a single agent notice, and you go to the bottom of that page and it has that consent to transition from a single agent broker to a transaction broker. Again, paragraph 12 is where we see the different types of transaction relationships. So that is really the major difference between those core different versions of the forms. And let's move on to other forms. So we've got new forms from Florida Realtors, brand new form, compensation agreement, seller to buyer's broker, CASB-1, compensation agreement, seller's broker to buyer's broker. I will probably call this broker to broker compensation form, seller's broker to buyer's broker, CABB1. And we've got modifications to these compensation agreements. Again, I may call them an amendment, but they are modifications to these respective forms. Again, we've got the link here. If you would like to check up on the release of the forms as they come up as a result of the settlement, this website is updated quite frequently, either with new information, new forms, videos by Florida Realtors. It's a great resource if you practice here in Florida to stay up to date with everything that has been released. All right, we'll talk about other forms. Just generally, Kristen, can you kind of give me an overview of what other forms might exist in the universe of real estate, not necessarily Florida Realtors forms, but what we might see as we move forward in our transaction?
Yeah, so I think we can see all different types of forms. The important thing is that you document and pen your commission agreements, however those look, whether that's between you and directly with your customer, or it's you and a broker, or however the case may be. Whatever the negotiated process arrives at, it's got to be put to paper. I highly recommend not relying on oral agreements, highly recommend not relying on text messages and emails, because that is going to just create a real mess when you try to enforce these terms. So there's lots of different forms out there, both through Florida Realtors, through local boards, and attorney-created forms that are created for brokers. You've got the buyer broker agreements, which we just reviewed. These are important because everyone has to use these forms now moving forward if you work with buyers and want to be covered under the MLS settlement. So if you want to be covered under that settlement, you gotta use these forms. So you've got those out there. Obviously, we always have listing agreements. Listing agreements are actually required under Chapter 475. So you would be violating state law if you don't have a listing agreement and provides listing services on an exclusive basis to a seller. Commission agreements is kind of my catch-all term to describe lots of different ways, different contracts that document commission in some form or fashion. This could be a commission agreement between a seller and a broker for just a one-off maybe offer. This could be like a for sale by owner type of situation. A commission agreement could be in place between two brokers. You could also have a commission agreement in place between a seller and a buyer's agent. It could come up in a lot of ways. Co-brokerage tends to refer to situations where there is more than one broker involved in representing a customer. So this happens a lot in the listing world, where maybe two brokerages are working on the listing. I see this more in the commercial context, but I've seen it in residential as well. So know that that's out there. And then, of course, you have referral agreements. There's very much could be a world and a situation where the commission terms are just not ironing out. The buyer maybe doesn't have the funds to pay commission out of pocket. The seller doesn't want to compensate the buyer's agent any funds, and there's no money to go around in that situation, and there's no compensation that can be agreed to. In that situation, it might be best as a buyer's agent just to refer the agreement, refer the transaction if the buyer is okay with it directly to the listing agent, and work out the compensation that way. So you've got lots of different options. Just know that there's lots of different types of contracts out there, and I encourage everyone to work with their brokers to figure out what forms are best for the specific situation, because all of these are going to be very fact specific, because of the way that these all have to be negotiated very extensively now. So keep that in mind.
As I'm going to plead with you as a title attorney, closing agent, to make sure your closing agents know how you're getting compensated and from who. It's so very important. You know, as a closing agent, we're accustomed to sending out a request for commission verification, and they come back with a percentage or a dollar amount, and we customarily will put that dollar amount on the seller's column of the settlement statement. But we in the title business know that we cannot just assume that one particular party is going to be paying compensation. So the commission verification form, if it doesn't ask the question, how much and by whom, make sure you're providing that information to the closing agent. So in a perfect world, the compensation or commission verification form might say, you know, how much of compensation due to you by a broker is being paid by the buyer? How much is being paid by the seller? How much is being paid by the listing broker? And again, making sure that that combination of fees does not exceed the amount in your buyer broker agreement. So make sure you've got the documentation, you provide the closing agent with who's paying what, and have the documentation to back up that information, because your compensation as a buyer's agent may come from multiple sources, or it may come directly, all from the listing broker, but you want to make sure you have the documentation to back it up, so that we can also appropriately allocate it on the settlement statement. And if your closing agent is not yet up to speed on what's happening in our industry, have them watch our webinar. They can understand what these forms are and what they might see moving forward. And then, of course, ask the better questions as to who, how much you're getting paid and from whom. All right, let's dive into the new Florida Realtors forms. The specific forms are the compensation agreement, seller's broker to buyer's broker. That's the first agreement we're going to talk about. That is the CABB one, seller's broker to buyer's broker. I'm calling it a broker to broker compensation agreement, but that is who will be listed on the this form. Again, it's the Florida Realtors form that was released a few weeks ago. You've got two brokerages that are going to be listed as the parties. You're going to specify that particular property. And if you know who the buyer is that you're working with, include that name of the buyer. If you don't, you have a few buyers that you're working with. You just want to have this memorialized between the brokers as to how much compensation would be provided between the listing broker and the buyer's broker at closing for this particular property address. You've got this memorialization. So as Kristen talked about, making sure you're having that discussion with the listing broker up front, and then once you hang up the phone, you've got the documentation that is going to be signed by the brokers to back that up. All right, so in this agreement, we've got a term of the agreement. We're saying this compensation agreement, again, between broker and broker, buyer's broker and listing broker, will take effect when a fully executed copy has been delivered to all parties to this agreement and will remain in effect for blank. There is a default term of 30 days. You can extend that term, of course. In no event will the term extend past the termination date of the seller broker's current listing of the property, including any extensions or effective protection periods, except upon full execution of a contract for sale and purchase by a buyer of the property procured by the buyer's broker. The term will automatically extend to the date of the actual closing of the purchase agreement. Of course, that makes sense. So between broker to broker, we've got an agreement for a period of X days that this compensation agreement will take effect when a fully executed copy has been delivered to all parties to the agreement. So between the brokers, everyone gets a copy and will continue in effect for X number of days. But in no event is a listing agent going to be responsible for paying compensation if their listing has expired, right? If the current listing has terminated, that buyer, that listing broker is no longer going to be obligated to pay, unless a full execution of a contract exists prior to the termination date. Of course, then the term of this broker-to-broker compensation agreement will extend until the closing of the actual purchase and sale contract. So we've got our buyer broker compensation, paragraph 5. We're saying seller's broker is going to compensate buyer's broker as stated below at closing of the property if the buyer identified in paragraph 1 closes on the property and the buyer's broker is the procuring cause of the sale during the term. However, if you don't know who your buyer is, you're working with multiple buyers and no buyers identified in paragraph 3 above, then buyer's broker will be compensated at closing of the property if the buyer's broker is in fact the procuring cause of the sale of the property during the term. And now we have the compensation agreement itself, the dollar amount, again, that the listing broker is agreeing to compensate the buyer's broker, whether it's a flat fee, a percentage of the purchase price, perhaps plus a transaction fee or something, or some other compensation, again, between the listing broker and the buyer's broker. We also have a provision for other terms. Even if this agreement is between brokers, make sure that you're getting this language approved by your broker itself or by counsel if you do include some other terms in this broker to broker compensation agreement. There's an opportunity for seller's broker and buyer's broker to acknowledge receipt of page 1, which is page 1 of 2. Again, nobody's going to be slip sheeting a page 1 to some signature pages that follow on page 2. And really, most importantly, it's in italics, but I wish it was in bold and all caps, the language at the bottom that says the parties acknowledge that this form should not be used to share offers of compensation to buyer brokers or other buyer representatives via any field in the MLS, meaning you have this form that is completed, let's say as a listing broker, you've got this form completed because you know what your listing agreement says is going to offer compensation to a buyer's broker. Do not upload this form into MLS. Do not do it. Don't do it. Don't even reference it, and don't put a link to it. Don't reference it. This again is an agreement that is off of MLS, not on MLS, off of MLS, negotiated to memorialize the terms that have been negotiated between buyer's broker and the listing broker. Do not put it on MLS. Again, that italics language at the bottom, I do wish was in all caps and bold. Kristen, anything I missed on broker compensation here?
Nope, we've got the magic language, which you're going to see in all the paragraphs about conditions are not set by law and fully negotiable. Just to jog our memory, because now you've been watching our class for quite some time. That was directly out of the settlement agreement. So that language is now in everything. It has to be conspicuous. It's conspicuous. So it will be bold. It will be underlined. It will be something to that effect. But your consumers will now be on notice that they can negotiate with you.
Yes. So as Kristen mentioned, that the language right above the signature line has that big bold language. And also it has the additional language, in no event will buyer's broker compensation exceed the amount of compensation in the buyer's broker's separate written agreement with the buyer. We talked about this in the context of the buyer broker agreement. We're going to say it again here. Again, in no event can the buyer broker be compensated an amount that exceeds the amount in that buyer broker agreement and agreed to by the buyer. Just a quick note on paragraph 6 regarding arbitration. There, by initialing, the brokers can agree to resolve any dispute related to this agreement by arbitration. And That's it. Okay, so it's signed by the broker or authorized representative. Kristen and I already talked about, if you are a licensed associate, do you have the authority to sign? Check with your broker to confirm whether you do in fact have the authority to sign on behalf of your broker. But this form, again, when you've got a buyer that you're working with, you contact a listing agent and you don't know what compensation, if any, is being offered, you contact the listing agent as the buyer's agent and you say, does your listing agreement have an offer of compensation to me as a buyer's agent? They say yes. You ask, great, I'd like X, or this is what it's required. This is the amount of compensation that is required. And then this is the document that will memorialize it. This is what creates the contract between buyer's broker and listing broker. So without offers of compensation listed on MLS, the agreement between brokers to pay compensation between a listing broker and a buyer's broker exists in this form. Okay. We're going to dive into the agreement between the seller's broker and the buyer's broker again. So let's say that the listing agreement is silent as to buyer broker compensation. You contact the listing agent and say, hey, is your brokerage offering compensation to a buyer's broker? And they say no. The next question the buyer's agent can ask is, well, is the seller willing to compensate me directly? And you ask the question, they say, well, maybe. And then you negotiate that amount of compensation, and then you memorialize it in writing. Again, this form is between the buyer's broker and the seller. Quick note here, buyer's broker, you're not going to contact the seller directly. You're going to still negotiate through that listing broker, so you're not going to circumvent the listing broker. But this form is going to memorialize the agreement between the buyer's broker and the seller with respect to a particular property that is listed by a seller's broker. We've got the term of the agreement. Again, the default term here is 30 days. Similar provisions to the broker to broker compensation agreement. Paragraph 4, we're saying if the buyer's broker is procuring cause of the sale of the property during the term of this agreement, then the seller is going to compensate the buyer's broker as stated below at the closing of the property. And again, the negotiated terms are whether it's a flat fee, a percentage of the purchase price, plus maybe a transaction fee, or other terms. Again, other terms. Oh, if you are if you're the listing agent on behalf of the seller, make sure your seller understands that if they have any questions regarding the other terms that might be offered by the buyer's broker, that they should maybe seek counsel if they have any questions regarding the terms. And if you are the buyer broker who is putting in additional terms, make sure that language, again, is approved by your broker and preferably also approved by counsel. Seller and the buyer's broker are acknowledging receipt of a copy of this page, which is page 1 of 2, and everybody's still agreeing that this form will not be used to share offers of compensation to buyer brokers or other buyer representatives via any fields in MLS. So again, note to our listing agents, if the seller is agreeing to pay a buyer's broker compensation, you are not putting this or its terms in MLS. You're not referencing it in MLS. It is a document that will exist outside of the multiple listing service. Again, negotiated between the seller and the buyer's broker via the listing agent. Also, sellers acknowledging that compensation paid to a buyer's broker, even though the seller is the one who's paying the buyer's broker, compensation paid to a buyer's broker is for services that the buyer's broker is providing to the buyer. Let's rewind for a second. So remember, our seller under this agreement is offsetting the compensation that would be due to a buyer's broker as agreed upon between the buyer and the buyer broker in that buyer broker agreement, right? So the seller is saying, yeah, I recognize that you as a buyer's broker are not providing services to me. I'm paying compensation to you as a buyer's broker for the services you as the buyer broker are paying or providing to your buyer. Okay, we've got our dispute resolution provision. It's a little bit lengthier than the broker-to-broker compensation agreement. So all controversies will be first attempted to be resolved by mediation. If litigation arises, then there's prevailing parties attorney fee provision. And if the parties agree, then they can agree to resolve disputes that are not resolved by mediation via arbitration. Again, if you are the buyer's broker, you want to make sure you get your broker's blessing before submitting something to arbitration or initialing that clause regarding arbitration. We're saying that this agreement, of course, will be construed under Florida law and electronic signatures will be acceptable and binding. And we've got our big bold language again, surprise, brokers' commissions are not set by law and are fully negotiable. And in no event will brokers' compensation in this agreement exceed, or total compensation to a buyer's broker cannot exceed the amount of compensation in the written agreement with the buyer. Did I miss anything? I think we got it all. Yeah. Okay, so the other new Florida Realtors forms, we're not going to go through them in detail, but just know that there are modifications to the compensation agreement, MCA1 and MCA2. They either allow extension of the term of those agreements, again, the broker to broker or seller to broker, buyer broker compensation agreement. They can allow modification of the financial terms or other terms, and they, of course, are going to be signed by the same parties who executed those original agreements. So modifications, I call them amendments, y'all call them modifications of those compensation agreements that we just talked about, the CABB one and the CASB one. What is next? What's coming up from Florida Realtors? Oof, according to Florida, yeah, go ahead. Yes, please. I need some caffeine.
Yes. So we're anticipating an amended showing agreement and an amended retainer agreement, a modification to buyer broker agreement form, which is going to be very important in those situations where the compensation may be offered on a transaction is more than what was in your buyer broker agreement, and you need to negotiate with your consumer how that additional amount is going to be accounted for. So you might have to modify your buyer broker agreement to make it go up. You might have to credit it back to the buyer, which we're going to talk about next, but know that you're going to have that modification agreement that way you can adjust terms as needed. That's also going to give you the ability to extend the contract, hopefully, and make other changes that happen as you negotiate these things. We have not seen the modification form yet, but as soon as it's out, we'll go over it with you. The other thing that needs to come out, and we have not focused on here today, is the amended listing agreement. So right now, the listing agreements are set up, at least from a Florida Realtors perspective, and some of the other forms that are published by local boards, that they kind of are set up in a way that sets the commission to be offered on the MLS. So a lot of times in those agreements, a seller is going to agree whether or not to place the property on the MLS, and then how much compensation is going to be offered on the MLS. Starting in August, once the changes go into effect, there's going to be a shutoff of the MLS field, which means you're not going to be able to make that offer on the MLS. Depending on what your listing agreements say, that could potentially mean you're in breach of your listing agreement because you can no longer offer compensation on the MLS. So in those circumstances, you may need to amend your agreements to let the seller make a determination whether they're still going to offer cooperating commission, and if they are, how is that authorized to be communicated to buyers agents, whether that's something you can do on advertising, is that something you can do on your website, something like that. There is an obligation, if you read through the FAQs, which we're going to give you at the end, that are have been published by NAR, that you have an obligation to notify pending consumers no matter what. Any consumer that you have now, whether it's a buyer or seller, you have to notify them now to let them know that commissions are negotiable and you have to give this certain notice. And you might even have to go back and amend your contracts depending on how they read for that MLS field. So keep that in mind, be on the lookout for the new listing agreements, and take an audit now of what listing agreements you have in place that could potentially be impacted once the MLS field comes off the MLS. The FAR contract is also under review. That contract also specifically references MLS offers of compensation, which will be obsolete next year. So that will need to be modified as well. So we're really looking at sweeping changes across all forms, but just keep them in mind as we've received them. We review them and try to answer questions for all our brokers. And as of the recording today, we've given you everything we got, which is July 19th.
Oh, wow. Yes. Yeah. So in the next couple of weeks, there will be all of these additional forms should be released. And so we will do another update. In fact, our next Get Closed, Get Paid live class, live by Zoom, is August 9th. So we will review all of the forms that have been released to date, and again, including some of these forms that we're anticipating being released very soon. All right, Kristen, let's talk about credit and our sales contracts and sort of why we would talk about credit at all. So we talked about broker to broker compensation. We talked about seller to buyer broker. And then there may be that third scenario where a seller at the time of listing the property did not agree to offer compensation to a buyer's broker. Then what opportunity might there be to have a buyer compensation due under that buyer broker agreement offset by a third party or offset by the seller?
So commission credits are allowed. We're going to get into the statute in a moment. But there's all types of credits. Credits we see in transactions all the time, and they cross hands between agents and their consumers, and they also cross between buyers and sellers back towards each other to offset certain fees in the transaction. I call this moving fees across the line from one column to the next column. And this happens for a variety of reasons. It can happen because something came up in an inspection. It can happen because at walkthrough something's missing. All kinds of situations lead to a credit needing to be offered in some form or fashion, or money going from one way to the other. Where we see this happening more now is that there could be situations, like we said, where sellers maybe don't authorize buyers agents, or sorry, their listing agents to offer compensation to buyer's agents, but they might be willing to give some compensation to the buyer to offset those costs. So keep in mind that these are going to potentially be out there. There could be situations where the money is strictly changing hands between the buyer and the seller. And in those circumstances, it might be documented in the purchase contract. There could also though be, but I caution everyone not to use the purchase contract to amend contracts between brokers. When we're talking about what we're about to talk about, know that we're only talking about actual exchange of funds between a buyer and a seller in connection with the purchase contract, because brokers are not parties to the purchase contract. So the rule that allows us to do this, if we want to scroll down, is Rule 6(1)(j)(2) -10.02a kickbacks and rebates. So this is a rule that says you cannot pay a non-licensee a kickback or a rebate or a referral or anything of that sort, or any compensation as a real estate licensee. You can't pay that to a third party who doesn't have a license. So it's the anti-kickback rule. But there's an exception to this rule, which is where this comes into play for providing credits in connection with the transaction. That's subpart 2, which says the sharing of brokerage compensation by a licensee with a party to the real estate transaction with full disclosure to all interested parties is not considered a violation of Chapter 475. So the way to do this is in a compliant manner is for whoever's going to be making the credit, whether it's coming from the listing side or the buyer side, they provide a broker authorization letter. Remember, this compensation needs to be approved by the broker of the company because the compensation is due to the broker. They need to sign off on that, and then it needs to be noticed to all parties in the transaction. I interpret that broad language to mean it needs to go to the title company, it needs to go to the buyer, it needs to go to the seller, it needs to go to the other broker, and it needs to go to the lender. Historically, credits could get a little bit hairy if they reach certain amounts that were subject to caps based on the lender. So we're going to talk about the guidance that we have as of today on how that's going to work in the future. Just know that these rules that we talk about are temporary guidance, and these are not set in stone yet. Like everything we've talked about today, we are literally in a state of flux. So we're working off of today. We've taught you what the rules go into effect in August. And we started by saying, just know that these rules go into effect next month, but they're actually not being approved by the court until November. So when you talk about really just operating in a world that's at a changing pace, know that the same is happening in the lender world. It is not easy to rewrite rules overnight. So that's why we're only letting you know that these are guidance that we have as of today. And I believe I didn't mention it now that I went on that tangent, that all the changes we went through today is based on what is actually read in the settlement. We actually haven't seen the MLS or the NAR rule changes published yet. Hopefully those come out by next month, but those rule changes might also change some of the nuance of how this is applied. But for now, we're operating strictly based on what the settlement agreement says. And then we might have to revisit how rules read. So just keep that in mind. Be on the lookout for any update you receive from Florida Realtors, from your broker, from
NAR.
NAR,
NAR, yeah.
your local board,
Yeah.
MLS.
Yeah. So just before I jump into letter considerations, I want to recap what you said about sort of documenting that if a credit's coming from a listing broker or a buyer's broker to a party to the transaction. What is the appropriate piece of paper that should be documenting it? We're going to say it's not an amendment or an addendum to the sales contract, because that is between buyer broker, or between buyer and seller. Amendment to the sales contract is solely between buyer and seller. But what is the piece of paper that if I'm a buyer's agent and I'm looking to provide a credit to either party to the transaction, what is that piece of paper that I'm looking for that I can show as evidence? Who do I need the authority from? The broker.
Broker. So are you talking about the broker authorization letter, or what do we want to call it?
Yes, I am.
Okay, so
whatever you want to call it.
I know. I say broker authorization letter. The other term would be broker disbursement. Have you seen something called a broker disbursement?
Yes. Yep. Disbursement authorization. Yes.
Yeah, something like that. But what's important to know is that the broker is in the loop and the broker has approved it. I've seen title companies that will just approve based on an email. But for the most part, they want it on letterhead and they want it signed. Maybe that's not wet signature, maybe e-signature is okay, but the broker has signed and approved what the amount is. And the reason for that is that, like we said, the compensation is due to the broker. So there's no way of a title company knowing what your split is and how much you can credit within the confines of your commission split. So this got to come from the broker. Does that answer the question?
It sure does. Yes. Thank you. Yes. Okay. So let's dive into letter considerations, and just want a quick note that recently the NAR FAQ, will provide a link at the end, but the NAR FAQ is actually updated to sort of reflect some of the things that we're going to talk about here. Is that we know that sometimes in a loan transaction, there are caps on the interested party contributions that a buyer can receive in a loan closing. And there was some Fannie and Freddie guidance, again, I've got the link here, that maybe if the seller is providing a credit for an item that is customarily paid for by the seller, then it may be excluded from the limits on the interested party contributions. That means that if let's say a seller is providing a credit to a buyer for, for a buyer's closing costs, buyer's attorney fees, or whatever, that would typically be part of a limit subject to the cap of the interested party contributions. But if the seller is providing a credit for an item customarily paid by the seller, I'm using the term customarily paid by the seller in quotes because that custom could change. But for now, we can take that to mean that potentially it would be excluded from the limits on the interested party contributions, meaning if a seller is going to pay a credit to a buyer for buyer broker compensation or towards buyer broker compensation, and we're arguing that buyer broker compensation is something that is customarily paid for by the seller, then potentially that could be excluded from the limits on the interested party contributions. I've got the link for the Fannie Freddie guidance there. And again, look at the NAR FAQ because they did update those frequently asked questions with respect to this. And traditionally, VA loans rules prohibit VA borrowers from paying real estate agents any compensation. And there's been a temporary suspension of this rule. Again, I've got the PDF link here, but just pay attention to the guidance as to sort of they update, and everyone and across our industry is navigating this shift. The idea is we don't want to penalize VA borrowers for working with brokers, and of course we want to make sure that everybody gets paid for the valuable services that they provide in a real estate transaction. So again, subject to change, the information that we have to date, but we'll keep you posted on what comes down the pipeline. All right, so impacts on our industry. There is a potential that there are some buyers who decide to go unrepresented. So you should have a conversation with your broker as to how you want to handle unrepresented buyers. Just know that if you've got a listing and you are going to provide services on behalf of a buyer that extends sort of beyond allowing a buyer access during your open house, but if you're actually negotiating an offer on behalf of a buyer or doing something on behalf of the buyer, that requires a buyer broker representation agreement. So just know, again, if your buyer comes into your open house and says, you know what, I don't have an agent that I'm working with and I want to, I want you to provide services to me on behalf of the buyer. I want you to negotiate on my behalf. I want you to, show me additional properties, that kind of thing. Again, that buyer would need that buyer representation agreement. I also foresee, and we're actually seeing it now, that there is sort of an opportunity for brokerages and agents to stand out by providing a la carte services for a variety of types of services that they're providing. So potentially your consumer who has identified the property that they're interested in purchasing and says, I'd like for you to prepare the sales contract to for this particular property, and negotiate my transaction and work with me through closing. Those services might be different, and the compensation potentially could be different for those services than it would be with someone that you work with for 6 months. You show them properties every weekend for a period of 6 months, and then you finally identify, the buyer finally identifies the property and then, moves forward through that transaction. So you might see some a la carte services for buyers. And of course, we know based on the last hour, we've been talking about buyers agents may be negotiating their compensation in conjunction with the negotiation of the sales contract. We want to make sure we're carefully reviewing our sales contracts and our commission agreements, document everything. Having that appropriate documentation is going to help you in the event of a dispute. And of course, if you are in a situation where there is a dispute regarding your broker compensation, as Kristen mentioned, it is the broker who would be filing suit, not the agent licensee. So you of course would need the cooperation from your broker to be able to handle those disputes, and consult with counsel if you are in a position where you feel you're entitled to compensation under any of these agreements. Consult with counsel because they will help to guide you through that process. All right, we talked about this just a little bit. So my plea with you, make sure your closing agents are updating their commission estoppel request form to ascertain which party pays which broker and how much is due to each broker. So at closing, the settlement statement is complete and accurate as to reflect the actual compensation due to the brokers. And this, will be also a bit of a moving target. What to do in the event of a commission dispute? What if the buyer can't pay? What if they don't want to pay? What if the seller doesn't agree to pay? Do they agreed to pay before? What if the broker threatens to sue each other, to sue you, to sue the title company? What if the brokers have a dispute with each other? Just have these conversations with your broker in advance, right? Have the conversation to figure out what their policy is, and maybe they have a go-to counsel to be able to help navigate through those agreements. But again, the more you have documented, the better for all parties. Kristen, do you want to talk about lien rights and buyer broker agreements real quick?
Yeah. So
we're about out of time. Okay.
Yeah. So lien rights, there are certain contracts that have lien right language in the buyer broker agreements. The language usually references a Chapter 475 provision that says a broker cannot lien property unless there's some sort of written agreement between the parties allowing such lien rights. There's nothing in Chapter 475 in the residential contracts that sets a statutory lien process. There is for the commercial world, but there isn't in residential world. So when you see that lien right language, some folks think, oh my God, you can lien my property right away. I'm of the position, and this is just my opinion, that at this time the buyer signs the buyer broker agreement, they have no interest in the property in which they can actually grant lien rights to, because you have to own the property to be able to grant a lien and interest in it. But I caution you because if there is lien right language and a dispute arises, that might give an avenue for a broker, if they have the right to litigate against the property, obtain a judgment, and then that judgment might become a lien on property. That also, the fact that you have a buyer that potentially signs a buyer broker agreement and commits to paying a certain amount of commission at closing, could arguably be considered a debt. And at the time of closing, when the buyer needs to sign their borrower affidavit saying they have not signed or agreed to anything that could potentially impact this property, that could make that a little bit of a hairy acknowledgement for the buyer, because they may know that they have agreed to pay a large sum that could lead to legal challenges involving their property in the future. So all those challenges are out there. Disputes, I think, are bound to happen. The way you can protect yourself is making sure everyone is on the same page, and that can be hard to do.
Yes, yes. And also we've got a resource slide here as well. And of course, if you ask us, we will happily provide this resource list and clickable links, but just know that your local boards will have resources for you. And actually, as of today, Florida Realtors website was just updated to include a few new classes related to the buyer broker agreement. So if you are interested in attending some of the Florida Realtors courses, I strongly encourage you to go to the Florida Realtors website and sort of click through. There are a number of opportunities to get comfortable with the new form, to hear from brokers' perspectives. So there's some phenomenal instructors who are going to be teaching some of these classes. And we are two attorneys. We're not brokers, but we understand the forms. But maybe if you hear these same types of presentations from different perspectives, they'll be able to make you more comfortable as we move forward. Of course, thank you as always. Please contact us with any questions. Our Get Closed, Get Paid classes are offered free by Zoom the second Tuesday of the month. And then of course we upload them onto our YouTube page for replay. And you can look at our schedule on our website by using the QR code. And thank you. I think that's it for today.
Yes, that was a lot. We thank everyone for their time, and tune into our classes the second Tuesday of the month at 10 a.m.
I know, I said it too. Awesome, great. We'll see you next time.